Hello everyone. The Umkhonto weSizwe Party has legally instructed the Secretary of Parliament, Xolile George, and Chief Justice Zondo to refrain from convening the sitting of both houses of Parliament until its grievances over the results of the recent elections are heard and ruled upon. Failing to heed this call, the MK said it will interdict the intended sittings. The letter stated, "Our client intends to challenge the validity of the declaration of the results by the IEC pursuant to which the aforesaid lists were compiled. If the said decision reviewed and set aside, then the envisaged processes will be legally incompetent. For ease of reference, a copy of the relevant letter of demand sent to the IEC is annexed here marked X. As a result of its genuine grievances, as inter alia set out in Annexure X, our client has taken a decision for its 58 nominees to boycott and not to attend the envisaged first sitting scheduled to take within the next 9 days or so. This will mean that the National Assembly will not have the requisite minimum number of 350 sworn-in members to constitute it, a question which is totally different to the quorum required for a properly constituted National Assembly. To the extent that you may dispute our interpretation, a court of law will be called upon to resolve that dispute as discussed below. The interpretation that Section 53(1)b of the Constitution applies to the question of the proper constitution or composition of the National Assembly is highly disputed. In the circumstances, we are instructed to demand, as we hereby do, that either or both of two offices which are currently seized with convening and or conducting the aforesaid first sitting, namely the Office of Chief Justice and or the Secretary to Parliament, must refrain from doing so, as this will constitute an infringement on the constitutional rights of our clients, its nominees, its members, and more importantly, its voters, and indeed the South African people as a whole. In that regard, we request that you give an understanding that you will desist from such conduct by no later by 10 o'clock on Sunday, 9 June 2024, failing which our client will be left with no option but to approach the appropriate court of law to seek inter alia an order interdicting you from going ahead. Due to the urgency of the matter, we have taken the liberty of sending this joint letter to the two relevant offices and to do so separately to each. In the event of the undertaking not being furnished, kindly furnish us with details of your attorneys plus permission to serve the relevant court papers on them." The Parliament responded and said, "Dear Mr. Zungu, your letter dated 7 June 2024 to Secretary to Parliament referred to me for response bears reference. I note your concerns and your interpretation of Section 46 of the Constitution. I do not agree with your interpretation and am of the view that the Secretary to Parliament is legally bound to facilitate the first sitting of Parliament at a date and time to be determined by Chief Justice. Accordingly, unless and until the results of election are set aside by a court pursuant to Section 49(3) of the Constitution, Parliament must ensure that the sittings take place as directed. I take this opportunity to remind you that the first sitting of the Assembly and the National Council of Provinces will be physical sittings, and arrangements have been made by parliamentary administration to ensure that all members who appear on the IEC list as handed over by the Chief Justice, as provided with travel and accommodation to attend the sittings and associated onboarding activities scheduled in Cape Town. Given your response, the correspondence, we will instruct the officials to cancel all arrangements in respect of accommodation and flights to your client's elected members so as not to incur fruitless and wasteful expenditure in contravention of the financial management of Parliament and provincial legislature